Hello, and welcome to today's event, which asks the question, should online marketplaces be liable for defective products? My name is Sujay Shivakumar, and I am the Associate Director of the Center for Data Innovation, which is a nonprofit, nonpartisan think tank focusing on the intersection of data, innovation, and public policy. Recent court decisions in California find Amazon liable for a defective third-party product, even when Amazon is not involved in the production and fulfillment of that product. So today we ask, what are the issues at stake? How do they reflect a changing legal and economic understanding of the role of product liability in ensuring consumer safety? And given the large size of California's economy, what are the implications of these decisions for the future viability of a diverse ecosystem of online marketplaces? To answer these questions, we are very fortunate today to have with us some leading experts. We have Jeremy Robinson, who is a partner at Casey Geary LLP, Justin Brookman, the Director of Consumer Privacy and Technology Policy at Consumer Union, Nathan Garnett, General Counsel at OfferUp, and Catherine Sharkey, the Siegel Family Professor of Regulatory Law and Policy at the New York University's School of Law. I will briefly introduce each speaker before their intervention, and we will reserve the final quarter of the hour for discussion and questions from the audience. So please use Slido on the website or in the YouTube description to submit your questions. Thank you. So let's get started. So first up, we have Jeremy Robinson, who secured the precedent-setting decision against Amazon in Bulger versus Amazon.com, and more recently assisted with Loomis versus Amazon. Jeremy is the chair of Casey Geary's motion and appellate practice and is widely acknowledged as one of the premier legal writers and analysts in the state of California. We look forward to hearing his unique perspective on these cases and also his view of the policy reasons behind why online marketplaces should bear some of the responsibility. Jeremy, over to you.
Okay, thank you. And thank you to the ITIF for allowing me to speak today. This is really a fascinating issue, and I think I'm not exaggerating when I say this is probably the most important product liability issue that's arisen in maybe the past 50 years. And honestly, this is just the start of it. I have a pretty limited amount of time, so I'm just going to go over some of the status of the current case law and legislation on these kind of issues, but it is a tremendously dense and difficult area, and so there's a lot to discuss. So traditionally, under product liability law, the seller of a product was strictly liable for any damages that resulted from the product defect. And there's a few reasons for that. The first is that the seller can spread the risk of loss up the stream of distribution. So the seller can get indemnity agreements or other types of contractual arrangements with the manufacturer, with the wholesaler, distributor, and so forth, so that the seller doesn't bear the brunt of any product defects. The second reason is that the seller can influence the manufacturer in ways to make the product safer. So for example, if Target says, we're not going to carry your product unless you can make your product safe or you can assure us your product is safe, that's going to encourage the manufacturer to make the product safer. And the final reason is that the seller sometimes is in the only position to help compensate the injured party. If the manufacturer is judgment proof or is overseas or something like that, sometimes the seller is the only available party. That's the traditional setup, and that's the restatement setup. Some states have modified their product liability statutes since then. Some states have innocent seller defenses or various other sort of restrictions on those kinds of things, but pretty much every state has some variety of seller liability. So that worked up until very recently, because until very recently, there wasn't really much of a question as to who the seller was. If I go into Target and I buy a can of shaving cream and that can of shaving cream explodes, well, it's pretty well understood that Target is the seller of that product. There have been a few outliers. There are questions about like auctioneers or consignment sales. Those created a few thorny issues, but for the most part, those were small issues compared to the main thrust of the product liability doctrine. Unfortunately, online e-commerce has totally upended that particular model. because now you have companies that do online marketplaces where third-party sellers sell their products, and there really is a big question about who the actual seller is for the purpose of product liability. So I use Amazon as an example here because Amazon is not only is obviously the biggest of these companies, but is the one that's been involved in almost all of the litigation thus far. And for a while, Amazon was very successful in convincing courts that it was not the seller of the product for product liability purposes. Its argument is, we don't take title to the product, we don't set the price of the product. We're basically just a platform that allows other people to sell their stuff, basically sort of a platinum Craigslist, if you will. And that argument has worked for a while. There were a few courts, the Fourth Circuit and the Sixth Circuit, both sided with Amazon on that issue, construing Maryland and Tennessee law, respectively, and several district courts, federal district courts, had gone with them on that as well. So enter Oberdorf, Bulger, and Loomis. So these are the three cases that have really turned the tide. Oberdorf was a case from the Third Circuit, and that opinion has since been vacated, so it doesn't have any precedential value anymore. But it was really the first instance where an appellate court was willing to consider the possibility that Amazon could be liable for a product it sold under strict liability. So as I said, the Oberdorf was vacated. Amazon petitioned for rehearing en banc. They got it. The Third Circuit certified the question to the Pennsylvania Supreme Court, and the case settled before the Pennsylvania Supreme Court ever resolved the question. So it remains unknown in Pennsylvania. But then we had Bulger and Loomis. So these are both cases out of California. And Bulger involved a case where a woman, Angela Bulger, purchased a replacement laptop battery off Amazon, and the battery exploded while it was in her laptop and badly burned her. Really, bad chemical burns on her legs and arms, really terrible injuries. And the third-party vendor of the product was a company called Lenoge, which was located in China, and they were unreachable. We tried to get Lenoge to respond to a complaint, and they wouldn't. So we went after Amazon as the seller of the product. And Amazon made the usual arguments, we're not the seller and so forth. But the Court of Appeal in our case said, we believe that Amazon should be strictly liable for this type of sale. They do basically everything that a retailer or seller does, short potentially of taking title to the product and a few other minor things. But they have injected themselves into the chain of distribution, into the stream of commerce, and therefore they should be liable for that. Loomis was a decision that followed up on that. Loomis was one of the infamous hoverboard cases. This was a hoverboard that caught fire and burned down a house. And again, Amazon made their usual arguments about not being the seller, and the Court of Appeal disagreed with them. This is a different Court of Appeal in California. Disagreed with them. It followed Bulger and said that Amazon is the seller of the product for the purposes of strict liability under the law of this state. And the main difference between Bulger and Loomis is that Bulger involved a fulfilled by Amazon product, meaning Amazon actually had possession of the product, and Loomis did not. And Loomis, the third-party vendor, actually shipped the product directly from China. And so these two decisions have really turned the corner on product liability for online marketplaces. In fact, they were both considered so good that the California legislature, that was previously considered legislation to hold the online marketplaces liable, has basically tabled that legislation as being unnecessary. And both those decisions go through some pretty lengthy policy discussions about why Amazon should be held liable. But a lot of it turns back to what I mentioned at the beginning about Amazon can spread the risk, Amazon can influence manufacturing because of its power and its size, and Amazon, in many cases, is the only party available to the plaintiff. So now the question is, how does this extend outside of California? And that's one of the big issues. The next big case that we're waiting on is McMillan, and that's coming out of the Supreme Court of Texas. That'll come out in probably a month or so. And if McMillan goes the way of the plaintiff, then that will be a big shift, because now that will signal states other than California are willing to hold Amazon liable as well. And that would be really a seismic shift, I think, as far as that's concerned. As I mentioned, various states have various different types of product liability statutes, and that complicates things because some states have definitions of sellers in their statutes, and those definitions were created before the e-commerce age, so they obviously aren't going to include companies like Amazon. And in those states, I think really legislative action is the only thing that's going to change that. Otherwise, the courts are going to be bound to follow that. So that's basically the lay of the law. The reasons, I have very limited time, but just, the basic reasons for holding the online marketplaces liable, at least in Amazon's case, is that they are doing almost everything that a retailer does. I mean, Amazon processes the payment, Amazon gets paid, they take a commission from every sale, they do all of the marketing, they have the entire customer interaction. When you buy a product off Amazon, you don't interact with the third-party seller, you interact with Amazon. And all of these things basically make Amazon a retailer. And so Amazon should take the responsibilities of being a retailer as well as the benefits. And obviously they're getting a lot of benefits out of that. Now, of course, the tricky question becomes, well, what about the other online marketplaces that aren't as involved as Amazon? Where do you draw the line? And that's where things get difficult. So, if you have 6 reasons why Amazon's a retailer, what if you have only 5 for eBay or 4 for Etsy or one of those kind of things, 3 for Google Shopping? Are those companies also responsible? And that's really going to be where this is going to land. The courts are really going to have to grapple with that, and legislatures, both state and potentially the US Congress, are going to have to consider those issues, and those are very, very complicated and difficult issues to decide. So there's a lot to look for going forward. So I don't want to take up too much time. I know we got a lot of other good speakers to hear from, so I'm going to pass it back at this point. Thank you.
Thank you, Jeremy. Some of those issues are precisely what it is that we want to unpack over the course of this hour. But just in terms of the next speaker, I'm pleased to introduce Justin Brookman, who is the Director, Consumer Privacy and Technology Policy for Consumers Union, the policy and advocacy arm of Consumer Reports. In this role, Jeremy works to shape the digital marketplace in a way that empowers consumers. So, Justin, if you could sort of describe your view in terms of how these recent rulings on product liability impact the interests of consumers, among other perspectives that you bring to this.
Yeah, absolutely. Thank you. And thanks to ITIF for putting this event together. So in thinking about whether and how to hold platforms liable, I think it's important to think through what the purpose of product liability is, right? Traditionally in tort law, if you were harmed, you had to prove negligence, but that's hard and expensive and maybe unknowable, and it's clunky and it's hard for consumers to reliably get relief. It's a very inefficient process. And eventually the courts decided, well, we should make the manufacturer strictly liable for defective products without a consumer having to prove negligence or anything. As Jeremy said, they're the best position to bear and distribute the costs from defective products. So if you're Coca-Cola and 100 bottles of Coke are just going to blow up every year, Coca-Cola should bear the cost of that. They should pay out the damages. And if the profits outweigh the liability, they'll continue to offer the product, or they'll raise prices, or they'll switch to cans. But they're best position to do it. And the goal is to make sure consumers are made whole and to make sure that the market internalizes the cost of harmful products. And over time, that concept expanded beyond the manufacturer, so to other links in the chain. So now it includes the store or the seller. They might be best positioned, or at least better positioned than the consumer, to bear and distribute the costs of defective products. And so now a store or a manufacturer could be wholly or partly liable, but the goal of the law remains to make sure that damaged consumers are made whole, and then to apportion liability between the various layers of the chain, such as possible and such as is fair. And in the case of Amazon, I think I agree with Jeremy. I don't think it's really a close call. I mean, they're clearly playing an integral role in putting products into commerce and are best positioned to spread those costs around. So, people go to Amazon.com, they pay Amazon processes the credit card statement, they pay Amazon Prime membership fees, they communicate with Amazon if there's a problem, they want a refund or replacement, they go to Amazon. Amazon has A to Z guarantee about safe and effective products. Historically, you bought the product directly from Amazon itself. They've since opened up the platform to third-party sellers over time. I'm not sure how much consumers actually understand that. If you go to the product page, it's often really obscure who's actually selling it. It's a small hyperlink off in the corner. And as someone like who is trained to try to find it, I often have trouble trying to figure out who's actually selling a product I'm trying to purchase. In some ways, I feel like Amazon is actually coasting off the brand it built up as a first-party seller and like the moat that it has as the everything store, and they're profiting, I think, from a lot of third-party, kind of maybe shady third-party sellers. And so like, Amazon's the fourth largest company in the world. I think it's well positioned to bear the cost of defective products and then to distribute those costs however they see fit. They can make the decision to ban particular product lines or certain merchants if the costs outweigh the profits. It can demand proof of insurance, which it does in many cases for certain product lines or for certain sellers. It can demand proof of identity. It can mandate merchants to post a bond or to consent to service a process. It can raise prices. So if like 1 in 1,000 hoverboards are just going to blow up, they can make this decision that this is still a profitable business and people, the demand still justifies selling the product, and then they are well positioned to make consumers whole. Even Amazon now apparently agrees with this. So as Jeremy said, last year, California was considering AB 3262. That would clarify that product liability applies to online marketplaces just like it does to physical stores. Amazon opposed it for most of the session, and then when it was close to passing, they were like, well, if it applies to us, it should probably apply to our competitors too. And so they convinced the bill sponsors to make it a lot more expansive. This was a last minute change, and then due to all the uncertainty about, okay, what does this actually mean now? The bill ended up not advancing. Maybe this was like ninth dimensional chess, like super clever of Amazon to end up killing the bill. But their official position now is that they should bear the costs of defective products sold on their site. As Jeremy mentioned, after the Loomis decision, the bill sponsors were like, maybe we don't actually need this bill anymore, because it sounds like in California, the law is pretty clear about applying at least to Amazon. I do think it's a hard and important question about where to draw the line. I think Amazon, certainly, I think should be liable. But if I buy a product through a message board or Craigslist, probably not. And there are a lot of intermediaries in that chain too, like ISPs or hosting providers or Amazon Web Services. I don't think Amazon should be liable just because they host a website. But Etsy and eBay, I think, is a harder question, and maybe. But I think that's the core question. What are the indicia of involvement to justify imposing liability for defective products? AB 3262 didn't really do that. It just kind of punted it to traditional product liability law. It mostly just tried to clarify that Section 230 of the Communications Decency Act wasn't a defense to product liability actions. And I think that's definitely right. I don't find Section 230 compelling as a defense. This is about a platform fulfilling a transaction. It's not about Amazon as a speaker. It's about whether Amazon is putting products into commerce or not. But where the right line is, I'm candidly not sure. We're actually starting out working on a white paper to try to answer this question, like what attributes of a marketplace justify what level of regulation or liability. I do think that payment processing feels pretty important. If a platform's one that charges your credit card, that feels like you're the one, that's the party that you have a financial relationship with. Maybe that's the most important. Maybe that's enough. I don't feel that coming into possession of it is really that compelling. I don't think as a practical matter, it really matters. Amazon's actually inspecting these hoverboards to make sure they work. And neither did the California courts, because they just decided it wasn't a relevant consideration, that the other attributes of Amazon's involvement justify holding them strictly liable. I do think, I'm clear-eyed that there are definitely consequences from this. Consumers are made whole, the ones who are damaged, but it definitely has real-world consequences and costs. So, maybe hoverboards are going to be more expensive. Maybe they're not going to be sold at all. I think that's fine. I think that's the right policy result, because it makes the market internalize the harms and costs of defective products, and it puts the decision-making on the entity that's in the best position to do it. And the hard work is going to be in figuring out how far down the line that goes. And I look forward to hearing from other speakers if they have clear answers on that. Thank you.
Thanks, Justin, and look forward to that white paper that you mentioned as well. It's now my pleasure to introduce Nathan Garnett, who is a general counsel at OfferUp. Some of the discussion earlier talked about what attributes of a marketplace are exposed to this level of liability, and it also is the case that some these precedents are going to impact different types of marketplaces in different ways. Nathan joins us today despite enduring major dental surgery just yesterday, so we're very glad to have him with us today. And I hope he can give us an understanding of how these recent liability cases actually impact online marketplaces such as OfferUp. Nathan.
Yeah. Great, thank you. Yeah, and I'm doing fine. Maybe it's the drugs, but I was concerned about my ability to participate after having my wisdom teeth pulled, but I seem to be doing okay. So appreciate that. So yeah, appreciate the perspectives of the prior speakers. They already walked through some of the case law, so I won't. I will cut off the first part of the remarks that I was going to make. But what I'll say is first I want to introduce what OfferUp is for those of you who may not be familiar with it, and then talk about I guess the spectrum of marketplaces. So Justin mentioned, I think both speakers mentioned that where you draw the line is a pretty important question, and it's not an easy one to answer. So when the Bulger case came out and I read it, my reaction as a lawyer who took torts law as a 1L was that, yeah, this makes sense, right? Amazon, other than the kind of legal fiction of them not taking title, are doing all of the things that a traditional retailer would do. They have possession of the item, they process the payment, they do the customer service, and you often, and as a Amazon customer, often you really have to look hard to know whether you're buying from Amazon or not. Whether you're buying technically from Amazon or whether you're buying from a third-party seller in their marketplace is often not super clear, particularly if you're not super familiar with the platform. And so to me, it makes sense in that case that you would say, all right, well, you're essentially acting as a retailer, so we're going to treat you the same. I think, you can look at the far end of the spectrum. On the other side would be, a classifieds advertisement in a newspaper. There was a variation on the California bill last year that the newspapers were unhappy about because they felt that the language as amended at that particular point was so broad as to bring them in. I spoke to Chairman Stone earlier this year while that bill was still pending, and he was confused as to why they were upset. As someone who read the bill at the time, I'm not confused. At that point, there would definitely, if I was their counsel, I would have raised that issue. So where you draw that line, either if it's through legislation or through the judicial opinion, is a very difficult question, because these traditional notions of hey, the retailer's in the next best position after the manufacturer to assess the risk and to bear the burden and to do the sorts of things that would ensure that there is not future harms. It's not clear. So the Bulger factors. So I'll admit that I find the Loomis case very confusing. I, having read it, cannot clearly advise my client on what we should or should not be doing. And I don't think from a policy perspective, that's a great place to be. It feels very, very wishy-washy. So in a second, I'm going to walk through the Bulger factors, but first I'd like to talk about what OfferUp is. So we call ourselves a mobile goods marketplace. Think of us as a lot like Craigslist, but better. We're a mobile phone app based primarily. We do have a website. And the vast majority of our transactions are individuals meeting face to face to sell extra items that are in their garage or in their basement. Our founder founded us when he needed to clear out a room because he was having a baby and he needed to create a nursery. And he said, God, I wish there was an easier way for me to get rid of all this stuff. And at that point, smartphones were pretty new, and so he's like, why can't I just take a picture of something and post it? And so that's how OfferUp started. I think in general, there may be some disagreement, but in general, the concept of OfferUp bearing liability for one individual selling a product that was in their garage that's used to another probably doesn't make sense. OfferUp has no ability to assess the quality of it. They have no, it's a one-off transaction. The person posted it for free. OfferUp wasn't in the payment transaction. It was essentially acting as an advertiser, an advertising medium. While I don't agree with the limits of what the prior speaker said about Section 230, I think my guess would be that we would both be in agreement that 230 would probably cover that particular transaction. We also do offer shipping, though, and it's not a huge percent of our overall transactions, but for people who want to enable a smaller, less expensive item to be shipped, and for somebody who's looking for a particular item and cannot find it in their own area, that's an option we offer. So through our partner Shippo, we'll send you a mailing label, and through our payment processing partner PayPal, Stripe, will allow you to process the transaction. And part of the reason we do that is that we were seeing fraud on the platform where some bad actors were saying, "Hey, ship me this item, or I'll ship you this item. Pay me through Venmo." And without us being in the transaction, we had no ability to moderate that and make sure that people weren't being taken advantage of. So that was one of the reasons why we offered that. So, and that for us, that's essentially a kind of a break-even offering. It's done more as a feature of the platform from a trust and safety perspective, and from an inventory liquidity perspective, than it is from a profit-making perspective. So that's where the more recent version of the bill had us concerned, because if strict liability were to be imposed on it, we would have to turn off that feature in California. So, so let me turn to the Bulger factors, which I think the Bulger court probably overdid it in terms of the number of factors. They probably didn't need that many. But in general, a summary would be that Amazon accepted possession of the item, they placed it in their warehouse, they advertised the item, they provided the product listing, they received payment, they shipped it in their own packaging, they controlled the conditions of sale, they limited access to seller information, meaning that all the customer service questions had to go through Amazon themselves, and they required indemnification indemnification from the sellers. In my mind, you probably only need 3 or 4 of those. And I think one of the things that didn't come through in Bulger as much as perhaps it could have was what I raised earlier about it not being super clear to the buyer that Amazon was in fact not the seller. Some combination of those, and I do think that having possession should be perhaps not completely dispositive in every situation, affirmatively or negatively, but it's pretty important because it does allow the marketplace to make an assessment of the quality of the good. If you're in the position of OfferUp when we're merely acting as a connecting buyer and seller, and we're not actually taking possession of it, and Etsy and eBay in the same position, I think they have very limited ability to assess that. And so the risk mitigation there really falls on, like, are you going to offer this service or not? Not necessarily like, is this particular item safe to buy or sell? I think they're really interesting questions. I think that where the California bill that was being considered made payment processing itself essentially dispositive, and for the reasons I said, I don't think that makes sense. And another concern I had, and so when Amazon changed their mind, I'm going to be very candid here. When Amazon changed their mind on that bill last year, it was not because they thought that was the right outcome. It's because they saw the writing on the wall and they wanted to, they knew that it would impact their other competitors far more than it would them. Amazon's got a lot of smart lawyers. I live in Seattle, so I know a lot of them. I'm sure that Amazon, when they created the FBA program, the Fulfilled by Amazon Marketplace program, they knew that the day was coming when they would be held strictly liable for it. So I don't think that any of these cases were a surprise to them. In fact, my guess would be that they were surprised that it took this long. And so Amazon, I think, saw this as an opportunity because they already took that risk in a knowledgeable way to drag the other marketplaces that have less risk mitigation factors, the ability to manage that risk, and drag them along, which would, if you're OfferUp, us, we'd look at, okay, well, do we turn off this feature that's actually a fairly small percentage of what we do? If you're eBay, you have to ask the question, like, do you continue to do business in California? What can you even do to mitigate risk when some of your sellers may be high volume sellers where you can really do an assessment of is this somebody I want to be doing business with? But what do you do about the individual who bought some electronics on sale and are marking them up and reselling them? It's very difficult to mitigate that risk, and then how do you bear it? So yeah, so I think I might be at my time, but I look forward to seeing how this evolves, and happy to answer questions when we get to that part of the session.
Thanks, Nathan. As you point out, there are a whole series of questions that this raises. And let me also finally introduce our final speaker. It's my honor to introduce Catherine Sharkey, the Siegel Family Professor of Regulatory Law and Policy at the New York University School of Law. She is one of the nation's leading authorities on economic loss rule, punitive damages, and federal preemption. And I'm counting on her to help us understand the meaning of emerging US case law, finding e-platforms and online marketplaces strictly liable in product cases. And Catherine, all within 10 minutes. So good luck.
Great, thank you. Well, most of that, I'm thankful to be included in this august panel, who've done individually and collectively a wonderful job, actually, of laying out both the legal landscape and some of the key issues. So let me do the following. I want to come back to something Jeremy started with about the kind of revolutionary nature of this topic. So I can provide at least one empirical data point, because I am a co-author of a torts case book, along with my colleague Richard Epstein, which is, he did this book alone for many iterations, and I've joined it. It's now in its 12th edition, and it's very rare, actually, for us to introduce major new cases in the first half of the case book. So I should say the second half is business torts and lots of action happening there. But in the first half of the case book, which includes products liability, it's very rare for us to find a new major case, not cases to talk about in the notes about further developments, but a new major case along the lines of, say, in products liability, the Escola concurrence by Justice Roger Traynor, who argued for the introduction of strict products liability. And we have introduced the Oberdorf case that was alluded to, the Third Circuit's case that was the first one to kind of turn the tide, again, to come back to the language used earlier on this issue. So it is a momentous legal development, and I think that it's worthwhile not only having this panel to discuss, but worthwhile for lawyers as well as academics to kind of start devoting some more attention to this question that has been around for a while. As we heard, and I think I would just sharpen the point, there really have been, I'd say, two major waves of this litigation. And up until about 2018, Amazon was prevailing, and courts, in some cases, because of the existing consumer product statutes or definitions, product liability statutes, and their narrow definitions of who's a seller, because of course all of these statutes predated, to use the language from one of the Ohio cases, it's like these statutes are like from the dinosaur age, if you think about the revolution that we've had in terms of e-commerce markets and the like. But Amazon was basically prevailing as courts held to a very narrow doctrinal definition that basically you were only a seller if you transferred title to the good. But then, as Jeremy and others have suggested, with Oberdorf, and then now this pair of cases in California, Oberdorf was kind of an inflection point, and certainly this next wave of litigation, it certainly looks as though the courts, to the extent that they have leeway, are very much kind of diving into the policy-intensive nature of the question. So that's just the legal landscape. And I think I want to make 3 points here today. First is really a historical one. It was alluded to before, thinking about the birth of strict products liability. If we go back even further, products cases were handled in contract law, not tort. And there was a very sharp privity limitation, namely that you had to be the direct seller to the buyer. And the real kind of progression of harms from products from contract into tort had to do with first the fall of the privity limitation, such that you could go after, on negligence, you could go after a remote manufacturer of a product, not just the immediate seller to you. And what was interesting about that is with the fall of privity and this rise of negligence-based cases against remote manufacturers, we then set up kind of the vast expansion of strict products liability, particularly for manufacturing defects. And the historical point that I think is relevant to today is that one could characterize this transformation in the mid-20th century, and I wanted to just read a little bit of language from Justice Trainor's concurrence in that Escola case that I mentioned before. This was literally a case of a Coca-Cola bottle exploding in the face of an individual. Justice Trainor remarked, quote, "As handicrafts have been replaced by mass production with its great markets and transportation facilities, the close relationship between the producer and consumer of a product has been altered." And so the first point that I want to make is that while we see, right, in the mid-20th century, that was in 1944, a concurrence, and then we see that concurrence becomes a majority position in 1965 in California, and then basically sweeps the nation, we see that this radical transformation of the economy from handicrafts, individuals selling one-on-one, to mass production changes the relationship between the producer and the consumer, and legal liability standards evolve and expand accordingly. I think we could argue that we are now in the midst, in the 21st century, of a similar kind of revolutionary change. The switch from the vast majority of products being bought in brick and mortar stores to the rapid revolutionary expanse of e-commerce and what that means. And so we are at this, I just want to accent that point again, we are at this, I think, very kind of revolutionary moment, a seismic shift with respect to how consumers are buying goods, if anything, only magnified during the time of a pandemic. And so it is time to address this topic. Second point I want to make is that I see what courts are doing, particularly the Bulger and the Loomis case suggests this, and we shall see with respect to other highest state Supreme Courts across the nation. There is an appetite for thinking about modern tort law problems in a what was coined by Judge Guido Calabresi as the cheapest cost avoider paradigm. I just wrote actually a book review in the Harvard Law Review that's called Modern Tort Law: Preventing Harms, Not Recognizing Wrongs. And the idea, it actually looks at some leading cases, including by the US Supreme Court in a failure to warn case that it recently decided, many products liability cases, many issues that have to do with liability for pharmaceutical companies and the like, outside of just this realm of whether Amazon should be considered a speaker. And they're looking, as the Loomis concurrence does, in whether or not an entity, in this case Amazon, is the quote unquote cheapest cost avoider. Well, whether they can be looked to in terms of the best entity to try to prevent harms. But the very final point I want to make, I know my time is limited and I want to invite other panelists to come, so hopefully we can discuss these issues, is we've kind of put a finger, I think one could say, if we're taking the cheapest cost avoider paradigm, how does this translate into a test? What are the articulable factors? How do we know which entity might be the cheapest cost avoider in terms of, as the judge in Loomis, the concurring justice, said, tort law will inspire Amazon to align its ingenuity with efficient consumer safety. What does this mean? What are the factors? A worry that I have that we see playing out here is that there's a kind of stunted growth. We see, for example, in the Oberdorf case, right after the Third Circuit certified this issue to the highest state Supreme Court, the case settled. We see Amazon trying mightily in many jurisdictions to get these cases before federal courts, not state courts, because my argument would mean that we need the evolution, the kind of common law evolution, to articulate what the framework should be. So we've seen that emerging in California, and we have some barriers, both in terms of what's going on in federal versus state courts, and, as has been alluded to too, some very outdated state statutes. I'll stop here so that we can have more of a conversation about some of these issues.
Thank you, Kathy. That was really putting a lot of this in perspective. And I think you're quite right. We are at a very, very important inflection point. Let me get a couple of questions started in terms of discussion. One is, I think this was also brought up earlier, in terms of the the smaller platforms' ability to absorb the costs of liability. To what extent are the recent developments somewhat anti-competitive?
So I think I'd be happy to address that, Nathan. I can't tell if you're speaking. So, I mean, there are, as Nathan mentioned, Amazon jumped out in support of this legislation, and there were concerns from the other online marketplaces that this was exactly the point, that Amazon has positioned itself in a way where it can absorb this kind of loss, but the other online marketplaces potentially can't. And, Amazon is obviously already under a bunch of antitrust scrutiny. There was that House report last year that took them to task for a variety of other types of anti-competitive conduct. And so it is potentially a concern. I think it's, one that could be alleviated in part, at least, by defining the parameters of liability a little bit better. And I understand, Nathan's concern is these opinions, they hold Amazon liable, but the question is, how far do you go along those lines? And so it is important to create some more usable criteria. I think one of the things, a few people have mentioned is, like, what do you do if somebody's selling a product out of their garage? And I think, at least under California law, used products generally aren't going to be subject to product liability, I think, automatically. If I'm selling my law school textbooks out of my garage, which are amazingly pristine for a law school, but if I'm selling them on a marketplace, there's not going to be liability for that kind of thing. I think the courts, and I assume the legislatures, are looking for bulk consumer product sellers of new consumer products. That's really what the target is for these kind of things.
So another question from audience asks, should there be a way to design online marketplaces so that that they would not be liable for defective products sold by others? I think some of the points that were made during the presentations was it's often hard to see who the seller is.
Yeah, I can take that one as somebody who works with our product team, and we talk about design, and we've had conversations about, like, hey, should we make any changes with respect to Loomis? And as I said before, hard pressed to do that. I think, what you don't want to do is create an ability for people to design completely around liability in a way that it's just you're not accomplishing the legitimate policy goals of strict liability. So if we gave Amazon a clear path to avoid having liability for something like an FBA product where it seems like there's a consensus that they perhaps ought to be liability, that's not a great outcome. I think I would reframe that question a little bit in terms of, should there be clear standards so that people understand when there's liability or not? And I say that not just as somebody in the position of representing a marketplace, but also as a consumer, right? I would like to know when I am buying, am I going to have recourse against the seller? Can I reach them even if they're outside of the country, or do I even know who they are? Am I going to have recourse against the marketplace? So having clear guidelines helps the sellers, helps the marketplaces, and helps consumers. And obviously, it's an evolving area. So we may be a ways out from that, but I wouldn't. So sorry, long-winded way of saying I wouldn't allow marketplace. I wouldn't do that to allow marketplaces to design around it. I would do it to provide clarity to all the parties involved.
Yeah, that's an excellent point. I was involved in the sort of the inner research end of both the California bills, neither of which ended up going through. But one of the concerns that they had about sort of laying out criteria is basically setting it up so that companies could engineer their way around it, which is that's the whole idea originally. The argument for holding Amazon liable is that it's essentially engineered its way around traditional strict product liability by forcing the third party to retain title and things like that. And the whole goal of strict liability, as I think Catherine said, is to get rid of the contractual or economic impediments that otherwise can be erected. But it's tricky. If you come up with criteria, then you've got companies who are going to say, all right, well, we're just going to design our business so we don't meet those criteria, technically speaking, but otherwise still function as we function. So it's a balance, and it's a difficult thing.
Yeah, and I think that the tough thing too, when you write broadly, as the most recent bill was definitely written very broadly, and I raised this with Chairman Stone when I spoke to him, was at some point in the future on our roadmap, we'd like to offer the ability for local merchants where you buy in person to, for you to buy an item on the app and then go pick it up at their site. Now, I think in general, you wouldn't look at that and say, well, that's, you've met the person face to face and bought it from the store. Is that just because we process the payment, should that mean that we now have liability? Like, you clearly have a connection to the buyer, and that gets trickier because yes, you've written a law that's now broad to try to catch exemptions, but then you've kind of cut off this whole other category of transactions that you didn't probably mean to capture.
So similar in that vein, there was a question asking, under the rationale given by the first two speakers, why not hold the payment processor or even the delivery service liable for defective products?
I certainly don't want to dominate the conversation here, but I'm happy to at least address that a little bit, because that's exactly the argument that Amazon makes. Mm-hmm. So in their briefs on both of our cases, their position is, well, if you hold us liable, you're holding UPS liable. You're going to hold FedEx liable. You're holding Visa and MasterCard liable. All we do essentially is aggregate the services that these other companies provide, and this is going to have this sort of windfall effect. Mm-hmm. And I think there's a couple of things to say about that. The first is that UPS doesn't sell products. I can't go to UPS's website and buy a product. The simple matter of they're just a delivery service. Same for Visa. I don't buy products from them. And there is actually a case in California, the Arriaga case, which was finance leasing, where the court said they're not liable. The finance lessor is not liable. They're not sufficiently involved in the transaction. And I think, I guess the other thing from a practical standpoint is, nobody's suing UPS yet. You would think, if some lawyer looked at these decisions and thought that this was going to be the wave of liability that they could start going after delivery companies, that they would try that. And no one realistically has looked at these decisions and thought, okay, this means that Visa's liable for this or UPS is liable. they truly are service providers. Their relationship is extremely tangential to the actual product sale. So that's my pitch on it.
I think too that there's a way. I mean, it's interesting because in some sense this goes against. While I don't disagree in general that having clearly articulated, standards can help all entities involved. Right, the evolution of common law standards is a little different from that. And so, for example, I alluded to there's a U.S. Supreme Court case. It's called DeVries. Interestingly, both the majority and the dissent think that the cheapest cost avoider framework is the right one, but they come to different conclusions. This is a bare metal defense case about whether or not, someone who makes a bare metal piece of equipment that then someone else later adds an asbestos product to it, who's the cheapest cost avoider? So I think theoretically we could even agree we want to put the liability on the party that can minimize risks, that can prevent harms, right? The idea, I think sometimes we think about tort law ex post, paying people who are injured, but I think a primary objective should be preventing these kinds of accidents. Now, as an empirical matter, it's going to be, we can have these fraught arguments about which entities. I think it's going to be harder to say that UPS is the cheapest cost avoider as compared to, say, Amazon, that not only touts itself, right, of having all of these vetting mechanisms in place, using highly sophisticated AI techniques and the like to sort of sort through products, et cetera. We can, even though there's not going to be an easy answer, I think that you can have stronger or weaker empirical arguments that look at which is the entity that's best positioned to ensure the safety of particular products. In addition to Jeremy just relying on sort of the ingenuity of lawyers and who they're going to, go after, I think we could have courts come up with that as a kind of theoretical framework and then entertain arguments. And again, this gets back, a couple of the panelists have alluded to this as well. We do want to be worried about business models that are designed to evade or avoid legal liability. I mean, what comes to mind is in the gig economy as well, there's been a whole slate of cases dealing with whether someone's an employer versus an independent contractor. And it shouldn't turn on what you call yourself. The same way as here, it shouldn't turn on whether you call yourself a seller or not. It has to do with the kind of control you're exercising. And that control leads to whether you're the party that has the best information about how to minimize, costs and accidents. So I think that should be the framework we use to look at this question.
Justin, to what degree are these marketplaces also responsible for fixing things like astroturfing, review hijacking, or misleading product descriptions? What is the responsibility of the online marketplace vis-a-vis the consumer here?
I think it's a good question. I think the law is not entirely clear on that. I think you can make an argument that they have obligations under unfair and deceptive acts and practices statute, that they have an obligation to use reasonable steps to protect against misinformation and fraudulent reviews. So the FTC and state attorneys general have interpreted UDAP law to require reasonable security, right? So you have to make sure the data is not shared and data is spewed. And so you're required at the platform to protect against outside threats under that law. I think you can make an argument that you have similar obligations, again, to protect against abuse of your platforms. And so, Amazon definitely has a fake review problem. I think if there were relatively low-cost steps that they could do to ameliorate that, I think you can make an argument that they have a legal obligation to do so. The Federal Trade Commission has endorsement guides, like rules for when you need to say you have a material connection to a product, and they're going to be updating them hopefully soon. And I think they're going to be talking about platform responsibilities or around misinformation and around what they need to be doing to address third-party abuse of their platform.
Nathan, any thoughts on that?
Yeah, I would say, I think it just depends on the marketplace business model, right? I think if you're Amazon, so I think one fundamental difference between OfferUp and Amazon, and obviously there are many, is we don't have a SKU catalog, right? If you're Amazon or you are a third-party seller, you align the product that you're selling within a SKU that is in their catalog. So they already have pictures available, they already have item descriptions available, and everything, while they may have hundreds of thousands or perhaps even millions of SKUs, they all fit within that category. For us, we are you post what you want. Like every item is essentially unique, and so for us to police those descriptions, I think would be logistically impossible. I would also argue that Section 230 would say that that truly is user-generated content in the sense that people are posting that information, so we shouldn't be responsible for it. So I think that the challenge though is I don't want to enable the worst possible actors to benefit, and we definitely look at Craigslist as in a lot of ways the way that we don't want to be, because they have a famously kind of libertarian view of how you interact, and trust and safety has always been top of mind for us. So while perhaps we're not legally required to right now, we do have reporting mechanisms that users can report. We use our own employees, we use outsourced employees, we use AI to check for the things that we need to be looking for, and every day we're adding new item types or new euphemisms that people trying to get around our stuff will use. So I'm not afraid of some sort of regulation that would require some efforts. It's just I would be cautious around some kind of strict liability around item descriptions because it becomes logistically impossible. And then what you're looking at is simply saying only those companies that can bear those costs should exist in the marketplace. And I mean, I guess you could make that as a policy decision, but you need to be open that that's a policy decision you're making.
So a number of you raised this issue of Section 230. Can you explain again why 230 doesn't apply and block these cases?
I mean, I can talk about it only just from the Bulger and Loomis opinion. I guess Loomis didn't even address it. They addressed it in Bulger, and a few other courts have rejected it as well. But the basic argument is that, and Justin can probably provide a little more context on it, but the idea is they're being held liable for selling a defective product. They aren't being held liable for the content of their website. And Amazon basically it has to admit that. Their argument is, well, the listing wouldn't exist but for our website, and therefore without the listing there's no sale, and without the sale there's no issue. The courts have pretty much uniformly gone against that argument to say, if you're being held liable because you're providing a defective product, that's not a Section 230 issue.
Right.
So Kathy, one final question in your direction. One of the rules of liability traditionally has been to balance the information asymmetry between buyer and seller, where the buyer is typically thought to be less informed. So, how does these holding intermediaries like online marketplaces affect this balance? And in terms of, you mentioned this, this inflection point beyond, the cheapest cost paradigm. Are there other issues that we need to be thinking about in terms of rebalancing this asymmetry that we talked about?
Yeah, so that's a great question. So with a minute remaining, my response here would be, I think that I was on a panel recently with some European law reformers, academics, and they have less litigation over there. So there weren't lawyers on this panel. But it was, as all of these issues always are, a stark reminder that in the US, with respect to product safety, we prioritize liability over regulation, whereas the Europeans are much more thinking about ex-ante regulation in this particular space. And I do think it is appropriate and time to think again about the balance. The Consumer Product Safety Commission is relatively much less active than, say, the FDA as an ex-ante regulator, and there may be more of a role for some federal regulators to play in this space. As everyone here, I'm sure, is aware, the Wall Street Journal, had a huge article in 2019 about the thousands of banned, unsafe products that were available on these sites, and one might wonder whether we could have some more activity from federal regulators. So I think that would be the other angle to bring in, is the balance between liability and regulation.
Well, this is a fascinating subject, and we could go on all day, but sadly we have to come to the end of our hour. I just want to thank each of you again for an extremely informative and interesting session. I also thank Sydney Burton, our producer, for today's webinar. She will again be at it on June 2nd for a half-day virtual conference on the issue of deepfakes, disinformation, and democracy. It sounds like a fascinating event, and I hope you will all register and attend that event. But for now, thank you for your attention. Take care and goodbye.
Thank you.
Thanks, everyone.